Hi dears, happy day. This is CSR Bharat Kumar, Faculty for Law. I hope you're really doing well today. We are going to cover some basics of CA Foundation law related subjects. So the topic that I'm going to cover is basics of 2CA in a CA Foundation. What is a 2CA in a CA Foundation? The two major acts that we are going to cover in a CA Foundation is Contract Act, which is your Indian Contract Act 1872, Companies Act, the Companies Act 2013. So majorly, we will cover this, and we know that if you cover this, you are going to cover the whole CA Foundation. How is that possible? Now, you can understand this by the following points that I wanted to say. Indian Contract Act is the mother of two acts. Indian Contract Act covers the provisions of both Sale of Goods Act 1930 and the provisions of Indian Partnership Act 1932. So even before 1930, Indian Contract Act was also involving the provisions of the sale of goods, and before 1932, where a separate act was there for partnership, it covered the provisions. So indirectly, Indian Contract Act covers Sale of Goods Act and Indian Partnership Act. Now, when you know about the second CA, which is the Companies Act, when you know the basics of Companies Act, and automatically you should understand there was a bridge which creates an understanding between your Indian Partnership Act and Companies Act, which is your LLP, Limited Liability Partnership Act 2008. So indirectly, if you know about this too, you can cover the basics of the CA Foundation. Now let's go into what are the basics of Indian Contract Act. To know about a contract, what you just wanted to know. Ingredients of Indian Contract Act 1872. So when we say the ingredients, that means the contents that we need for an contract to be made between parties to contract. Now what are they? Invitation to offer. Just because you give an invitation to offer, that does not mean it is going to be an offer. Anything that is only an invitation or anything that will precede an offer can be an invitation to offer. The word that I try to use is the invitation to offer may lead to an offer. So the word may is may or may not. I've never used a word called shall. So that's the keyword that we wanted to talk about on invitation to offer. Offer is just you proposing to do a particular act in a particular manner. When there are two parties, minimum two parties in a contract, one party is going to be an offerer or a proposer. The other party should obviously accept it. So there are two parties, one offer or proposal or an acceptance. I'm just touching the basics of Indian Contract Act. I am not expanding on the definitions in section 2. I am not talking about what the definition talks about. I am not talking about the rules of offer. I am not talking about communication and revocation. Indirectly, I have just told what and all are the contents in an offer. I am just touching the basics. So when we say offer is also there, and when the offer is accepted, when you say this is going to be a promise that we make for any person entering into a contract. So when we say promise, we say 2 plus 3. What is 2 plus 3? The second point here we are talking about is the offer. So the 2 is going to be offer or proposal. What is going to be 3? It is acceptance. So indirectly, offer plus acceptance becomes promise, or you can also say it as an accepted proposal becomes a promise. So when we say promise, there should be something in return for you to enter into a contract. I wanted to agree, or I wanted to enter into a contract with another person. There should be a proper consideration when I wanted to give something and get something. If you remember the touch of Sale of Goods Act, we would always say sale and agreement to sell. So when you wanted to sell, it is going to be buyer seller. Here, when there is a contractual term, we will talk about offer or offeree, or it is going to be the person who is going to offer or the person to whom it is to be accepted. So promise indirectly means offer plus acceptance, then only becomes a promise. But for that, you need to pay something in return. So we use a word called consideration. What is SIR? Something in return. So when you wanted to talk about something in return, it is going to be saying it can be in cash, or it can be in kind. So it can be for any consideration. Only then the promise becomes completed, and only when the promise is connected with consideration, we say it is called agreement. Agreement is nothing but 4 plus 5, which you mean it is promise plus consideration. In simple words, an agreement, whenever I wanted to agree something with some other person where there are the parties to contract, I need to ensure that offer and acceptance is already done with a promise, and there should be something in return, which we call it as quid pro quo. So that's the maxim that we wanted to expand on what is going to be for consideration. So agreement in simple words is promise plus consideration, which I told in an easy way for your numbering. Our mind, our psychologically, if it is going to work out, there should be a magic factor for you to remember it in your subconscious mind, so that it is not just in your temporary memory, but it is going to be for your permanent memory. So there are various things that we try to handle in the class. One is the colors that we use. Number two is the magic factor or the content in a flow that we wanted to give. The third is going to be the shortcut or the mnemonics which I talk about. Like for example, the moment when you see consideration is sir, you would not have got anything. So it would have got teased on saying that what is going to be the sir on consideration. So the moment when I say it is something in return, you will automatically get hold in your subconscious, so you will be able to remember it better. Why am I doing all this in law? Because law is for life. When we say law, we say longevity personified. Yes, that's what we have been doing all these times in the class. Now coming to agreement, we say 4 plus 5. You don't need to calculate it by doing a normal one. We say promise plus consideration. And all the agreements can become contracts. No, agreement can also be a social agreement. I just wanted to agree so that you offer and I accept, or vice versa, need not be to taking it in the court of law. So that means what they say, agreement is wider than contract. Contract is going to be an agreement enforceable in the court of law or enforced in the court of law. 6, to be enforced in the court of law. What does that mean? What is 6? Agreement. When you say agreement plus enforceability, it becomes contract. So to know about a word called Indian Contract Act 1872, you need to understand the contract is going to be relating to agreement plus enforceability. Agreement is equal to promise plus consideration. Consideration is something in return. Promise has two parties, promise or promisee. Here we use offer or offeree, or it is offerer or acceptor. Offer is otherwise called proposal. Before offer, there may be an invitation to offer, but definitely invitation to offer will precede an offer. This is the base for you to understand. If you expand on this for all the other 6 chapters, you know that invitation to offer, offer and acceptance relating, and the types of contract will be in chapter number 1. Consideration will be in chapter number 2. I am talking from the CA Foundation's perspective. Consideration will talk about 2 important doctrines: doctrine of privity of contract, doctrine of nudum pactum. The more important thing is law is always a 2 side of the coin. You cannot always say only head will be there. There can also be a tail. You cannot always be tails. It can also be heads. So that means when you say a provision is going to be yes, this is possible, there will always be an exception to that yes and say, in certain cases, there can also be a no for yes, vice versa. If you say no, it is not going to happen, there will always be an exception to no, where there can also be a yes. So it is 2 sides of the coin. Why am I telling this? This too only will be concentrated on doctrine of privity of contract and its exceptions, doctrine of nudum pactum and its exceptions, a very basic understanding of what is there in consideration. Then the third, you will talk about performances, you will talk about the promises, you will talk about the capacity to party, who can understand, who can do a contract, whether they are eligible or not eligible, all these things they will talk about. Then agreement, what is valid agreement, what is void agreement, what is lawful, what is unlawful, and then they will talk about breach. That means if you are not fulfilling your obligations to complete a contract, it is called breach of a contract. How they will discharge a contract through one of the points called breach. All this are the basics. It is very simple to know that when you start a contract, you need to complete it. You need to fulfill the obligations. How you will try to do? Yes, if you do it, these are all going to be the provisions. If you don't do it, it will lead to liquidated damages or penalty or any other negative side of not doing a particular activity. So these are the basics or ingredients of Indian Contract Act. I have brought some charts for understanding it, where we will talk about elements of contract. When we say elements of contract, we have already told agreement plus enforceability in the court of law. When you talk about agreement, it covers your offer and acceptance. And don't forget, here they are presuming that consideration also is done. So listen carefully. If you wanted to revise what we have done, offer plus acceptance is promise. Promise plus consideration is agreement. So consideration is presumed to be included in an offer and acceptance. So that's what they wanted to talk. What are the rules? What are the kinds? What are the essentials of the proposal? How you will communicate, how you will revoke it. Do the exact same thing for acceptance also. Do the exact rules for your acceptance also. So indirectly, you are going to cover the rules and essentials, which we are talking about as ingredients. This is a simple chart for you to understand, which I have taken it from the study material. Basics of agreement and contract. I told agreement is always bigger than the contract. Offer plus acceptance is the agreement, and it can also be a social agreement. For example, if your father says, yes, if you do really good in 12th standard and get more than 95%, I'm going to get you a car, and you agree between each other on that. And once you get the 95%, and if it's not going to get you a car, you cannot go and file a case against him, because it is not enforceable in the court of law. It is just an agreement that you had with your father. So that's an easy way for you to understand what is agreement and what is contract. Agreement is a wider term, contract is a narrower term. So all these keywords will make you realize what is going to be there. Offer, acceptance, and when you say legally enforceable, that means enforceable in the court of law. It is wider. It is going to be a narrower sense what we are talking about. Not necessary it creates a legal obligation. I was just talking about the father and son or a daughter duo. It definitely creates a legal obligation, because it goes and enforces in the court of law. So it should be done. All agreements are definitely not contracts, because agreements are wider, and contracts are definitely agreements, because agreements plus enforceability is contract. When you know the base of what we are studying in Indian contract, all these are going to be the repeated keywords that they will say it from the study material. Essentials. For you to have a valid contract, go and cover section 10. Go and cover section 10. What is there in section 10 of Indian contract? It will say what and all is required, what and all is not required, or what and all is given in section 10, what and all is not given. When we say agreement, we have already told free consent is going to be your agreeing the minds of the people, understanding that in the same thing, in the same sense. Let's take for an example. I am directly watching you guys and seeing you that, are you guys getting interest in the law? I don't need to ask that question, because I could see from your answering. And when you feel like it's been already 1 hour of law and all the provisions are done, you slightly move here and there, or you try to watch your time and see what is going to be there. I understood you are becoming cranky, so you need a small break, and then only we should continue. Now you have not told me that you wanted a break. Now you are not telling me that you are exhausted, but your acts are making me understand that you guys need a break really, really badly. So that is agreeing the same thing in the same sense, which we call it as consensus ad idem. So that is called free consent. When that free consent is not there, what and all is going to be the impact? That's what they will say here. Competence of party. You need to be major. You need to be a sound mind. That means you should not be a lunatic, and you should not get disqualified from any other provisions of the act. You should have a lawful consideration, lawful object, no void agreement. So all these are the keywords that they will say. Agreement should be there. Free consent, consensus add item should be there. Party should be competent. Consideration should be lawful. That means it should not be opposed or immoral to the public policy. Legal object should be legal. The purpose of why you wanted to do that should be, it should not be a void agreement, not expressly declared to be void. This is going to be one of the keywords. Next, what are the essential elements? We have told it in a full way. Now you should understand. We have already told it in the bullet points. Why are you creating a diagram? Why do we want this? Is to make your subconscious really strong on it. How much ever theory you study, a small chart, a small diagram, a representation of the ideas, or using a numbers game, or using an abbreviation or a mnemonics will make you remember. For me, law is equal to concept, provisions, and memory. All these are important. If you are not conceptually strong, you will not know what provisions we are talking about. If your memory is not good, you will not know what sections are covering under what, and you will never be able to proceed both for your life and for your exams. We know CA is only a part of life, but it's a very important part of your life. So you cannot miss a concept, you cannot miss provisions, you cannot obviously miss your memory also. So all these are going to be very crucial for you to know. So I just wanted to bring this. Types of contracts, they wanted to exclusively divide it by way of enforceability, how you wanted to form a contract, how you will have to perform a contract. If you know this basics, you will be able to understand these are the different types of contract, because not all the contracts are going to be same. Some can be enforceable, some is not enforceable, some is at the option of parties, whether it is valid or void. When I say valid, it is enforceable. When I say void, it is not enforceable in the court of law. When I say voidable, it is at the option of parties. Very simple example of voidable before we go to the next chart. Voidable. Stealing is good or bad? Immediately you will say it is a bad activity. Perfect. Now I will tell it as a different point. Your dad is going to be there, or I say stealing or taking money from a pocket is bad. So the first point you say it is a bad. Now how can we make it good? Your dad is not there in home, but you need to get medicines for your mom. So you take money from dad's pocket, which when he is not available, and you go get medicines for your mom. Now you can tell me whether it is good or bad. Now immediately you will say, sir, it seems like it is good because dad is not there, but we need to get medicines for mom. So I'm taking it from my dad's pocket is obviously fine. Now, the same story where I told it is bad or where you told it is bad now also happens to be good. So it is at the option of parties to decide whether it is valid or void, whether it is enforceable or not enforceable. That determines your voidable. But if it is illegal, then it is going to be punishable in the court of law. When you cannot enforce it, that means impossibility of performance, where we use a word called supervening impossibility, we will say it is unenforceable contracts. So these are the basics or the types of contracts to make you know what is there. Even before you know something, if you know that there is a chart representation, it makes your job really, really easy. Now, that meaning that we wanted to cover on this, I've just sum up, as we are not going to explain on this, but we should understand that all these are going to be the basics. When I say offer and when I say an when I say an acceptance, offer and acceptance becomes a promise, which is going to be defined in 2B. What is going to be consideration is 2D, and what is promise plus consideration is under 2E. And when you say offer and acceptance becomes a promise, it is going to be 2C, and contract agreement enforceable is under 2H. Now, why are we telling this to know A, B, C, D, E, H? If you know this, it is going to be easy. A, offer. B, promise. C, promise or promisee. D, consideration. E, agreement. H, contract. So this is for your understanding on section numbers. Now, many people ask us, sir, should the section numbers be definitely mucked up? Now, why are you seeing that as a mucking up factor? You will have to understand and dwell into the provisions, understand the sarams of the story, automatically 2-3 times revision. As I've already told you, just memory alone is not enough. Conceptually, if you are strong, memory should automatically come to you. This is the basics of what is going to be there. We did not stop with 2H. We are saying what is void. We are also saying what is voidable. And we are also saying it is going to be void contract. Now, void agreement is different from void contract. You will not even go inside a contract when it is void ab initio. That means right from the beginning, when it is not enforceable, you cannot make it a contract. In simple words, they are saying it might be a contract which was valid before, but it is going to be not valid later. These are the basics that you have for your void agreement and void contract. When it is void ab initio, it will never come under contract. What is ab initio? From the beginning, right from the beginning. So these are the keywords, are the maxims, are the jargons that we try to use. I was just talking about concentration, consideration, concentrating on that. I told you doctrine of privity of contract with exceptions, and nudum pactum, which is called no consideration, no contract. And you also have an exceptions for it, saying that apart from that also it is there. In simple words, they are saying if there is no consideration, there is no contract. That's called nudum pactum. But can there be a contract even without consideration? Yes. What are they? That's called exception. Simple example, a gift from a father. There is going to be a gift deed properly done under Indian Stamp Act 1899. There should be proper stamping. Everything is perfect. But will you give something back in return to your dad because he gave you a gift? No, not necessary. But there is a contractual term, but they need not be a consideration. There are 7 points on the exceptions to nudum pactum. Exactly. Another is doctrine of privity of contract. That means when A and B are entering into a contract, C cannot come, who is a stranger to a contract, cannot file a case or cannot sue a party to contract. Between A and B, they cannot do. But there are exceptions. That means where even a stranger to a contract can sue party to a contract. So there are various examples and exceptions on it. So that is going to be for consideration. Essential elements, we have already told you, if your capacity to contract, you should be a major, you should be sound, you should not be disqualified. And free consent, I was talking about consensus add item. When free consent is not there, it will all be negative, saying it can be a coercion, it can be undue influence, fraud, misrepresentation, and mistake. Now, there is a purpose why you wanted to give an into here. If it is very normal, if I give a tick, it is not going to disturb you. But I'm saying a negative term. If I put it in into, you will always keep that in your head that it is all not normally used in the terms of contract. Lawful consideration, I'll give a tick. Lawful object, I'll give a tick. Void agreement, I give an into because it's a negative aspect for your. Yes. Now we are going to cover the second CA, which is called Basics of Companies Act. When we are talking about Companies Act, just 5 ingredients I wanted to bring it for today so that you know what is there in your CA foundation in just under 2-3 minutes. What are the key 5 points that you have it under the company law? Number 1, 470, 29, and 7. Now, what is this? There are totally 470 sections, 29 chapters, and the schedules are 7 in number. Easy to understand. You know company. What is a company? What is going to be there under section 2, subsection 20? All this we can tell it in a definition. But how many types of companies are there? If I ask you how many types of companies, you will tell one type of a company, but you guys will not be able to consolidate and tell it in an easy way. How to make it in a consolidated way? Just a small magic factor thing that I brought it like a mnemonic, which is called camel. C, control. That means on the basis of control, you can find the type of company. A, access to capital. On the basis of access to capital, you can find. M, membership. Based on the number of members, you can define the type of company. E, external, other companies that we have not covered in any of the previous, and L is liability. So indirectly, control, access to capital, membership, liability. When you are not covering all that under this 4, it becomes external or other companies. So we say in easy word, camel companies, conceptually also you know, memory also you know. When we are talking about schedules, why are we importantly covering schedules is when we wanted to go to the accounting, they will talk about schedule 3 because based on schedule 3 only, the format of financial statements is going to be important. Financial statements include your balance sheet, profit and loss account, cash flow statement, statement of changes in equity if applicable, and notes forming part of the previous financial statements explained from 1 to 4. Now, I have not even told it fully, but I'm telling it in order because that's what should have been defined under section 2, subsection 40. When I say section 2, it is going to be all the definitions that we covered, irrespective of any act. Majorly, section 2 will concentrate only on the definitions perspective. When you ask me, sir, section 2 is the definitions for Companies Act. Section 1, what it is going to be? They will always talk about your applicability. So indirectly, what I will say is, before section 2, you will try to read about section 1, which is called SECA. Is this a mnemonics that we should remember? Yes, because S is short title, E is extent, C is commencement, and A is applicability. Easy way for you to understand. And this is section 1. And section 2 will talk about definitions where the schedules are getting connected. So when I talk about how to incorporate a company, again, when people blink on the section numbers and other things, you can easily say it is 7 into 7 into 7. What is this 7 into 7 into 7? You don't need to calculate. What is this 7? Is section 7 has 7 points or the 7 steps to calculate how to incorporate a company. In that 7 steps, it has 7 compliances, including the orders of the authorities. So how to remember this? Section 7 has 7 compliances or 7 points or 7 steps. In that 7 steps, you will have 7 compliances too. How easy it is for you to understand. Next, 2 important documents you will talk about in the company law. We call it as MOA and AOA, Memorandum of Association, Articles of Association. Various provisions will be there in chapter number 2, but in CA Foundation, very basics of what is MOA, AOA, and the doctrines related will be there. What are the 3 doctrines? Doctrines are ultra vires. So there are 3. You can remember that ultra vires is connected with MOA and UV is ultra vires, IM is indoor management, CN is constructive notice. So when we are talking about this, we are saying indoor management and constructive notice is directly connected with AOA, which is your bylaws, rules, and regulations. UV is ultra vires, which is connected with your memorandum of association, which is a charter of the company. Yes, this is the basics of what you are going to do in CA Foundation. I just wanted to sum up in just under half an hour to know that these ingredients, if you know about company law, I have indirectly told you how to study a company law. I also told you what are the provisions, what are the 2 sides of the coin, how to bring a numbers game, how to bring a psychological aspect to do it, how to take a break in the middle time, saying a consensus add item, how to bring a mnemonic or a shortcut. As I've already told you, concepts, provisions, and your memory is going to be important to make you really, really strong. So indirectly, we say longevity personified. Longevity personified is law for life. Law is not just for exams, but it is for life. So study it with enjoyment, like how you watch a movie. You will be able to cover it, law, in a very, very easy way. Thank you. Have an absolute great day and a fantastic year ahead. Thank you.